So to be able to understand what it entails, we need to understand a little bit about the Arcus case. So I'm just going to give you a very brief synopsis of the Arcus case. Very briefly, Mr. and Mrs. A were married for 19 years and had two daughters were born of the marriage. They were divorced and entered into a settlement agreement, which is often the case in divorce proceedings. It was made an order of court. Mr. A paid maintenance. He paid the direct payments. So things like school fees direct to the school, medical aid direct to the medical aid. But he did not pay the cash pay maintenance to Mrs. A, to her and the two daughters. Mrs. A, after 25 years, musters up the courage to go see an attorney, who sends out a letter of demand. At that stage, the maintenance escalated to a whopping 3.5 million. And Mr. A starts paying the current maintenance, but not the arrears. So Mr. A goes off to the maintenance court and he tries to get a retrospective discharge. So he tries to do away with the maintenance order. And he doesn't want to pay the arrears. And Mrs. A then issues a warrant of execution for the arrears. Mr. A then applies to the High Court for a stay of the warrant, pending the discharge of his application to the maintenance court, as well, and this is important, a declaration that the maintenance obligations in terms of his settlement agreement, which accrued before 2017, is extinguished by prescription. So it falls away. So he wanted the court to confirm that everything that he did not pay for that 22 years would fall away, and that he would only be liable for the last 3 years. So basically that the normal prescription period would kick in. The normal 3-year prescription period for an ordinary debt would kick in. The High Court ruled that the maintenance obligations contained in the settlement agreement and made an order of court is subject to a 30-year period. Mr. A was not happy with this, and he challenged it and went off to the Supreme Court of Appeal. So the legal question that both the High Court and the Supreme Court of Appeal had to grapple with was whether a maintenance order is a judgment debt that is subject to a 30-year prescription period, or whether it is like any other debt, subject to the usual 3-year prescription period. So both the High Court and the Supreme Court of Appeal were of the view that the maintenance orders are final and that the judgment debts for the purposes of the Prescription Act are subject to a 30-year prescription period. So that means that any maintenance beneficiary has a 30-year period to enforce their maintenance court orders. We hope that women out there, because it's often women, don't take 30 years or 25 years like Mrs. A to approach a court to enforce their maintenance orders. The Act applies whenever a legal duty exists of any person to maintain any other person, irrespective of the relationship between those persons giving rise to that duty. So that can be a mother and a child, a father and a child, a mother and a father. It can be a grandparent and a grandchild, wherever that legal duty exists. Maintenance defaulters should not be allowed to get away with non-payment for maintenance. And it's usually ex-wives and children. This perpetuates the hardship suffered by the most vulnerable groups in our society, women and children. This ruling simply confirms that maintenance beneficiaries have 30 years to enforce their maintenance court orders. Now, maintenance beneficiaries can enforce their court orders like Mrs. A did in this case with a warrant of execution and with other legal remedies available. Now, your second part of your question was who can enforce an order? If you have a court order in place, a maintenance court order in place, then you can enforce it through this process. So it doesn't necessarily need to be a divorce court order. You could have an unmarried mother with a maintenance order against a father for maintenance of a child. There are other legal relationships. It's not necessarily stems from a divorce. And you'd have the same remedies available provided there's a maintenance court order in place. Well, this is exactly what Mr. A attempted to do in this matter. His legal representatives argued that the usual prescription period applies to a normal debt of 3 years. So he should only pay his arrear maintenance for the last 3 years, and that the remaining 22 years should fall away even though he didn't pay maintenance. So both the High Court and the Supreme Court of Appeal did not agree with Mr. A's reasoning and confirmed that he needs to settle the outstanding maintenance for the last 25 years. So there are always going to be loopholes, but this loophole was closed in this case.